Resuming debate, the Honourable Member for Kitchener Centre.
Thank you, Mr. Speaker. I'm honoured to speak today in the debate over Bill C-10, the Safe Streets and Communities Act. I'm going to limit my remarks to the changes this bill makes to the Youth Criminal Justice Act. These changes were previously incorporated in Bill C-4, or what was known as Sebastian's Law. And those proposals are now in Part 4 of Bill C-10, clauses 167 to 204. The former Bill C-4 was first introduced on March 16, 2010, and was being reviewed by the House of Commons Standing Committee on Justice and Human Rights when the opposition caused Parliament to dissolve on March 26, 2011. 16 meetings had been held to study Bill C-4. Over 60 witnesses had already appeared before the committee. The problems with our current youth criminal justice system were recently highlighted by the results of 4 months of observation by the Toronto Star of a typical Canadian youth court. I'm going to briefly quote the conclusions reached. Quotes, changes to our sentencing law in 2003 were supposed to fix an over-reliance on custody. Instead, serious offenders are thumbing their noses at the courts because they know they will be treated lightly. Victims feel their voices are not heard. Kids who violently break the law, many from broken homes, are reoffending. Mr. Speaker, our government invests significantly in crime prevention, in rehabilitative measures, and in restorative justice. But a balanced approach to criminal justice requires that we also pay due regard to protecting the public and victims of crime against violent youth offenders and repeat youth offenders. And this is what Bill C-10 targets. A number of amendments to the youth justice provisions of Bill C-10 were tabled both by NDP and Liberal members of the Standing Committee during clause-by-clause consideration, and I'm going to comment on some of the more significant of those. One proposed amendment relates to protection of the public, specifically calling for the reinsertion of long-term ahead of the phrase protection of the public in the overarching principles of the Youth Criminal Justice Act. Mr. Speaker, in highlighting protection of the public in the Youth Criminal Justice Act, the government has responded directly to Recommendation 20 of the Nunn Commission report. The Nunn Commission was a Nova Scotia public inquiry which examined the circumstances surrounding the tragic death of Teresa McAvoy, who was struck and killed by a youth driving a stolen vehicle. Justice Nunn concluded that highlighting public safety as one of the primary goals of the Act was necessary to deal with the small group of repeated offenders who were spinning out of control. Mr. Speaker, we agree with the conclusion drawn by Justice Nunn that the current provisions of the Youth Criminal Justice Act are not sufficient to deal with this small group of dangerous and repeat offenders. Now, it's simply wrong to suggest that by removing the adjective long-term from ahead of the phrase protection of the public, we're forbidding consideration of long-term factors. No, Mr. Speaker, by removing a restrictive adjective, we're merely restoring the phrase protection of the public to its true meaning. In doing so, we're allowing judges to consider all factors relating to public protection, including short-term and long-term considerations. It's also very important to note that, just as it was before Bill C-10, protection of the public will continue to be simply one principle of the Act, alongside and equal to other principles such as emphasis on rehabilitation in Section 3.1b, fair and proportionate accountability in Section 3.1c, and special consideration for young persons in Section 3.1d of the Youth Criminal Justice Act. Now, another motion to amend called for the removal of specific deterrence and denunciation from the sentencing principles in the Youth Criminal Justice Act, and that's proposed by Clause 172 of Bill C-10. Mr. Speaker, by allowing judges to consider specific deterrence and denunciation in sentencing, and I say only allowing, not requiring, but allowing them, we increase confidence in the youth justice system. We simply give judges the right to choose the tools they feel necessary to deal with the needs of the differing young persons that come before them. In proposing this amendment, the government is not abandoning the current sentencing principles in the legislation. It is instead giving judges an additional tool to help deal with that small group of repeat and violent offenders where it's reasonable to consider specific deterrence or even denunciation for the benefit of the young person and in order to maintain the public's confidence in the administration of justice. Mr. Speaker, even this provision is limited in its effect because the application of these provisions, specific deterrence and denunciation, is subject to the principle that the sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. Another of our proposals that was discussed quite extensively at the Justice Committee was the test for publication in Clause 185 of Bill C-10. The opposition proposed to amend this clause to basically make this test optional rather than mandatory. Now, the wider circumstances under which publication bans may be lifted, proposed by Clause 185, fulfills our government's commitment to Canadians to ensure that young offenders will be named when the circumstances of their offence requires it. In our view, it would be inappropriate for this provision to be optional when the very purpose of the amendment is to protect the public, and that is not optional. The government is not calling for unlimited publication, but merely equipping judges with an additional tool for circumstances that require it. In fact, it should be noted that this provision only makes it mandatory for judges to consider, to think about publication. They are not required to order publication in any particular case. The threshold for this is also significant. The judge is required to consider the purpose and principles set out in Section 3 and 38 of the Youth Criminal Justice Act. And the judge must decide that the young person poses a significant risk of committing not just any offense, but a violent offense, and also must decide that the lifting of the ban is necessary to protect the public against that risk. If there is no significant risk of violence, or if any other solution makes publication unnecessary, then publication remains banned. Furthermore, the onus of convincing the court of these matters remains on the prosecutor. Mr. Speaker, our government recognizes the importance of our youth criminal justice system, and as such we propose changes in Bill C-10 to address the many concerns that Canadians have expressed about the shortcomings of the current system. Our government responded to calls for change from several provinces asking for modifications to the former Bill C-4. Manitoba, Alberta, and Nova Scotia officials appeared before the Commons Committee in June 2010 and subsequently provided suggested amendments in relation to pretrial detention, adult sentencing, and deferred custody and supervision orders. Our government considered these submissions and made changes to the applicable provisions found in clauses 169, 174 sub 2, 183 sub 1 of Bill C-10. These changes, Mr. Speaker, have been well received by the provinces that propose them and will ultimately strengthen the youth justice system. Le gouvernement a également déplacé à l'étude article par article de modifier l'article 168, remplacer le verbe encouragement par le verbe favoriser dans la version française de l'alinéa 3.1a2 de la loi. C'est un changement que le ministre Fournier de Quebec avait demandé. Mr. Speaker, this government is committed to the protection of our communities and to tackling crime committed by young persons. Our view is that this can be achieved without compromising the use of measures outside the judicial process and while still preserving non-custodial sentences for the vast majority of cases where such measures are appropriate. Part 4 of Bill C-10 provides judges and others working in the youth justice system with tools needed to deal appropriately with the differing needs of young people who come before them, including the needs of repeat and violent offenders who have not responded well under the current system. Such changes will restore public confidence to our youth criminal justice system. I invite all the members opposite to join us in these efforts by supporting this bill. Let us join and together take arms against a sea of troubles and by opposing, end them. Thank you very much, Mr. Speaker.
Question et commentaire. L'honorable député de Charlebourg au Saint-Charles.
L'Association du barreau canadien a joint sa voix aux députés du NPD et a émis le communiqué de presse en septembre dernier, soulignant que plusieurs aspects de la loi proposés par le gouvernement, dont les peines minimales obligatoires, dont la réutilisation de l'incarcération, dont les contraintes imposées aux juges, sont source de préoccupation. Est-ce que le gouvernement a l'intention d'écouter l'Association du barreau canadien?
The honourable member for Kitchener Centre.
Mr. Speaker, thank you very much for the question from my colleague across the way. What one would find if one examines this act is that mandatory minimum penalties are required only in cases which are particularly egregious. For example, there will be a mandatory minimum penalty for drug traffickers who engage people under the age of 18 in their business of trafficking drugs. There will be a mandatory minimum penalty for drug producers who set up shop in a residential neighborhood, a grow-op, and thereby cause danger of fire or otherwise to communities. There will be mandatory minimum penalties for drug traffickers who are engaged in organized crime. These are all very specifically targeted. They're offenses where Canadians would want us to impose jail sentences, and the government is going to pursue those remedies.
Questions and comments? The honourable member for Winnipeg North.
Thank you, Mr. Speaker. Mr. Speaker, what is very clear is in regards to the government's agenda behind Bill C-10 is to try to give Canadians as a whole that the government is concerned about crime, and they're bringing in this bill, and it's going to put a lot more people in jail, and somehow it's going to have an effect in terms of minimizing the amount of crime on our streets. And I believe that if you check with people, whether they're in Winnipeg North or anywhere in Canada, that the priority should be how do we prevent crimes from taking place in the first place, Mr. Speaker. That should be the government's #1 priority in terms of addressing the crime front. And I ask the member, to what degree does he believe if the government was to invest some of the resources that they're going to be allocating for these super jails modeled after the United States, to take some of those resources and invest them in things such as community policing, after school hours programming for young individuals? Would he not think that that would have more of an impact in terms of getting young people more involved in more positive things in our communities, thereby reducing the amount of crime at our local streets?
Member for Kitchener Centre.
Well, Mr. Speaker, I should begin by saying that one thing is for sure, and that is the money that we're going to save on the wasteful and ineffective long gun registry that member supports is going to be put into policing and into things which really will make our communities safer. But beyond that, Mr. Speaker, I happen to know from my own riding the amounts of money that our government does continue to devote to rehabilitation and prevention. For example, just to name one or two programs, our government has invested heavily in an anti-gang strategy. My own community received $3.5 million under that. It is in one community after another all across this country with a view to keeping vulnerable young people from being lured into gangs. We also, in my community of Kitchener, developed a program, a curriculum called the High on Life curriculum, which is being used in schools now, at least all across Ontario, if not Canada, to help convince young people that they don't have to do drugs to get high on life. There are other measures that our government has promoted and will continue to promote, but it's simply not enough that we only do that. And in fact, we're the only government that has a balanced approach to crime, balancing prevention, rehabilitation, with also appropriate respect for law and order.
Reprise de débat.